Hello everyone, I am Divijyoti Naik and today I am going to discuss on the topic Law of Insurance and General Principles of Insurance. Before knowing what is insurance law, let us first understand what is insurance. Here, insurance is a legal agreement between two parties, that is the insurance company and the individual. In simple words, it is a means of protection from financial loss. Next is the insurance law. The term insurance law usually refers to the law surrounding private insurance. It can broadly broken into three categories. That is regulation of the business of insurance, regulation of the content insurance policies, and regulation of claim handling. There are some kinds of insurance and the most common kinds of insurance are life insurance, fire insurance, marine insurance, and personal accident insurance. Next is general principles of insurance. There are seven general principles of insurance, and they are utmost good faith, insurable interest, indemnity, cause proxima, mitigation of loss, subrogation, and contribution. Let us first understand what is utmost good faith. This principle states that the insurer and the insured must disclose all material facts before the policy inception. Both the parties in insurance agreement needs to have full faith on each other. For example, Maria took a term insurance policy from XYZ company, but she didn't reveal the fact that she is a cigarette smoker. Maria died due to the cancer, whereas doctors mentioned that this was due to excessive consumption of cigarettes. In such cases, insurance company have full rights to reject claims mentioning that important facts were not revealed by policyholder. Next is insurable interest. Here, the insured person must suffer some financial loss by the damage of the insured object. In simple words, there are no financial gains and losses if you do not have ownership of that assets. For example, in auto insurance, mostly cases are rejected by insurer company just because person driving does not have ownership of that vehicle. Assume that you hit a person with a vehicle which does not belong to you. This means that you do not have any insurable interest associated with your vehicle. This is enough to reject auto insurance claims. It is a straightforward but important point of an insurance agreement to exist. Next is indemnity. Indemnity means security protection and compensation given against damage, loss, or injury. Principle of indemnity means protection or security up to loss or damages or insurance cover, whichever is lower. For example, let us assume that your automobile is actually insured for 50,000. During a claim process, insurance company analyze the damage of the vehicle is up to 10,000. In such cases, insurance company pays you 10,000 for your damage and not 50,000 which is mentioned under insurance coverage agreement. This concludes that compensation amount is directly linked with the amount of loss incurred. Next is cause proxima. Here, principle of proximate cause means either direct cause or nearest cause. This principle is applicable when damage are caused due to a lot of factors. For example, assume that Mr. John kept driving when there is a red signal and hit Mr. Sam which had a green signal. Due to the mistake of other person, Mr. Sam got personal injuries. Such incidents is categorized under principle of proximate cause which has caused injuries to Mr. Sam. Next is mitigation of loss. Principle of mitigation of loss means it is the responsibility of insured towards safeguarding and taking appropriate precautions in order to minimize the losses incurred on insured assets. For example, imagine Mrs. Imma's house has caught fire due to party and celebration event at her home. In this tragic scenario, Mrs. Imma must give her best to stop fire by all the possibilities. She should have called nearest fire department office using emergency fire extinguishers, etc. She should not be worrying and watching her house burning by thinking that her house is 100% covered for the fire insurance. Next is principle of subrogation. Principle of subrogation means substituting one creditor for another. You should understand the importance of insurance in your life. Once losses incurred against property are compensated to policyholder, the rights of property ownership go to their insurer. For example, let us assume that you are in a vehicle caused by a third party and you register a claim at the insurance company to cover that the damages on your medical as well as vehicle expenses. Here, insurance might take the ownership of your car as well as medical expenses in order to get claimed by file the lawsuit against individual accountable for the accident. Lastly, contribution. Principle of contribution means similar asset used by one or more than one businesses under two different types of insurance policies. This fundamental principle of insurance means that insured are unable to get compensation more than the actual loss, as well as insured cannot claim total amount with multiple insurer companies. For example, assume that Mr. Mike has insured his property worth 5 lakh with three insurer companies. Assuming that gets coverage of 3 lakh for each insurance. Due to some unforeseen situation, property get damaged up to 2 lakh of amount. In such cases, Mike can easily claim the whole loss for either one of the insurer company or he can claim partially from all three of the insurers. In any case, Mike will not be able to claim whole damage amount from all the three insurance companies. This is all about law of insurance and principles of insurance. Thank you for watching.